صباح الخير جميعا. يعني أهلا بكم في هذه الندوة الهامة جدا. خليني بس قبل ما ابتدي بس هقول حاجة اللي هي على لأي حد بس بيجي المركز لأول مرة. المركز هنا مركز بحثي، احنا جمعية أساسا يعني جمعية بحثية. فيعني احنا متأثرين بشكل مباشر من القانون من اللي هنتكلم عليه النهارده. عايز اقول بس ان التوجه الاستراتيجي للمركز الترانسليشن، في ناس محتاجه ترانسليشن. Do you have something? Okay, because behind you don't seem to have one. Okay. التوجه الاستراتيجي بتاع المركز ان هو يجمع ما بين الكفاءة الاقتصادية والعدالة الاجتماعية
for economic efficiency and social justice, because if these two elements are not brought together, then we cannot realize sustainable development. If we have a strong economy that works only for few, then this is the fragile growth. And if we have a just economy without efficiency, then the distribution is not even. And if we have neither of them, then this is a real a catastrophe. We should be in the green color square, which is real development or real sustainable development, and we are working towards achieving these points. Today we are discussing the new NGO law, and as you all know, we had the law 84 of 2008, which was regulating everything, and it was not the best law, but things were going on, and then a new law emerged, and I can confidently describe this law as a strange law that caused controversy because it rendered the civil society paralyzed. It was very problematic from a political and the human rights point of view. I was just discussing with my office that if you find a thief in one street, you cannot kill everyone to arrest this thief. So this is not the way to behave. And I have to say that the state exerted some effort to review that, and the president of Egypt asked for revision of this law, and we asked for this. We want all the NGO and those affected should be brought together. And here comes in the importance of this symposium. It's important not because of the esteemed commentators and speakers, and not because it discusses the NGO law, but because it refers to the practical role played by the civil society, because civil society should play an active role. Government shouldn't be working alone, even if it's the right thing to do. So to have a proposal submitted by civil society organizations themselves is a great thing in and of itself. Dr. Ziad is such a esteemed person, and I cannot do him justice. He is a lawyer and a legal expert in funding and legislation, and he is the former deputy prime minister and minister of international cooperation. He assumed many offices, including being a head of the administrative control authority and the investment authority, and he was a member of the central bank board, and he was a legal advisor to the Minister of Economy. He worked in a number of law firms here in Egypt and in the US, and he was also part of the Social Democratic Party. He was a member of the parliament representing Asyut. He has a long track record. He is the treasurer of Ahmed Bahaa Association in Asyut, and he is a dear friend of mine. We have Dr. Hussam Badrawi, and I cannot do him justice. He is the president of ONG department in the Faculty of Medicine. He was elected as the president of Education and Development Committee in the Parliament from 2000 to 2005. He has a long track record in reforming the education sector here in Egypt, and he published many books in this field. He assumed many offices, so this is a very abridged CV or bio. We have Dr. Ahmed Abu Ali, co-founder in Hassouna and Abu Ali Law Firm, and he is a board member in the ECES, and he works as a lawyer in commercial transactions and litigation. He practiced being a lawyer in the US among in with other countries, and he also works for the Egyptian Company for Communication as the head of Compensation and Redress Committee. Without further ado, I'd like to give Dr. Ziad 30 or 40 minutes to discuss his own version. We have this law on the computer, and make sure we will project the article under discussion on the screen. Good morning, everyone. Thank you, Dr. Abla, for this kind invitation, and thank you all for coming and participating today. I'm pleased and honored to be among my dear colleagues on the panel. Um, I will try not to be lengthy. I will not spend the whole 40 minutes. Allow me at the outset to tell you that we are not discussing the draft law submitted by me, because this is the norm, but the thing is beyond that. Just like Dr. Abla said, the recently issued law has proved to be defective. It stopped the activities of the NGO and the civil associations. It rendered their work risky, and these people want to serve the country without return. They give money, time, and effort in order to develop the country, and all of a sudden the law has become a source of intimidating and threatens. So when we had an opportunity to amend the law, I thought that this is a very positive indicator. But why should NGOs be only passive receivers? If we want to conduct a real dialogue, then the NGOs should be active participants to the dialogue, not only invitees or guests. And it's good that the government and the mosques want to conduct public dialogues on this very important topic, and NGOs shouldn't be passive receivers. NGOs should lead initiatives to submit their own version, and what I'm going to present today is not the only attempt in this regard. We have many versions submitted by those interested in the subject and by other NGOs, because it's not about a draft bill submitted by the government or amendments to the said law. We want to conduct a public dialogue. I was a bit worried that amending this law might just end up with amending a few articles here and there that were a source of some international criticism. So I was afraid that we will just be after minimum amendments. We have been discussing for 2 years this law, and I don't think that minimum amendments would be enough. If we can improve this law, then it's a positive indicator. But let me tell you that this is a protracted dilemma which has to do with the lack of trust between the government and civil society organizations. So it's a critical moment not only to amend the provisions and articles of this law, but also to conduct a public dialogue about the role of NGOs and ways to address the situation in line with the national interest, stability, and national security. That's why it's very important over the coming few weeks or a month to bring together all the interested parties to engage in a dialogue about the point and not discussing the notification period or the restoration periods extending for 30 days. This is the only way to make a big progress instead of peripheral amendments. I also want to add in this regard that the most important element or pillar in this discussion to raise all the points is to rediscuss the role of the NGOs in the society, and I consider NGOs are the third pillar for any activity. You have the government or the public sector, private sector, along with the civil society. Recognizing the fact that this is one of the major pillars for developing the society should be a cornerstone for our coming dialogue. Otherwise, we would be just amending slightly the law. We need to promote the idea that we should have representation of the members of the society. Of course, the political representation comes from the parliament. The professional representation can be in the form of professional syndicates or trade unions, and the social representation should be done through the different NGOs or civil society, without which the government cannot adopt a healthy dialogue with the society they are governing. And I think you all know what I refer to. So, without further ado in this regard, and in including my introductory remark, I'd like to say that our role is to initiate a dialogue on the topic itself and not phrasing of the provisions or articles, because this is just an expression of an idea, a philosophy, or a rationale. If you have the correct idea or a sound rationale, then the expression would follow in the correct way. What I tried to do here is to collect some main concepts to be discussed, not only to improve the draft bill, but to introduce a new approach for managing the NGO sector in the country. These concepts have to do with the registration or establishment process, whether this is an association, foundation, NGO, and the scope of work, what are the activities allowed or not allowed, and to what extent can these associations own some commercial activities, and there are certain legal jurisprudence or legal cases governing legal precedents. Many of the international criticisms leveled at the Egyptian government, including the NGOs complaint, have to do with foreign funding mechanism, which is very important because at the end of the day we are recipient countries. We are not givers or we are not donors, but we have some Egyptian organizations funding some foreign students. but for most of our history and for the coming period, we would be receiving some funds. This is very important, and some other countries found certain solutions to balance empowering NGOs and civil society organizations in order to be able to attract foreign funding, taking into consideration the national security, political stability, and non interference in domestic affairs. And this is a real dilemma. So, anyone submitting a draft bill should take that manner into consideration, that should be sensitively balanced. But most countries could strike a good balance between empowering NGOs and keeping national security intact. It's doable. In this introduction, I'd like to say that foreign funding sometimes is presented as the only problematic area. Yes, it's important, but this is not the only aspect in the NGO sector, and it's not the only barrier hindering the NGO sector. And I'm part of this sector, and many NGOs have nothing to do with foreign funding, but operational activities and normal governance and daily dealings with the government are very restrictive, that renders their activities very difficult to be implemented. So I'm not underestimating foreign funding, but I'm saying that it's imperative of us as part of the NGO sector to represent the problems faced by all the NGO staff in Egypt, not only those who depend in whole on foreign funding. We have dozens of NGOs who do not, or which do not receive foreign funding. In dealing with the law, some NGOs might find it impossible to operate. That's why we need to initiate a dialogue to make everyone aware of the fact that modifying and simplifying the law is in the benefit of everyone, and this has nothing to do with reducing foreign funding. This is a national campaign to save the NGO from the crack down that might be imposed because of foreign funding or any other reason. That's why major part of the proposal has to do with many details on the day-to-day activities with the management of the association, and all these details make the activities of the NGO really difficult, along with the foreign funding issue. And I'd like to stress that foreign funding issue is only 10% of the problematic areas of the draft bill. I'd like to refer to some of the concepts enlisted in my version that I hope will be taken into consideration. I'd also like to give the right to others, many other esteemed NGOs submitted versions. We need to take into consideration that establishment should be upon notification and not authorization, and this is a legal text, and what this is what is enlisted in the current draft bill, but it's a bit restrictive because the required documents for establishment are not listed. It's left to the executive regulation and to the national authority. If we want NGOs to register by notification and upon the willingness of the founders, then we need to rely only on net notification with clear required documents listed in the text of the law. But does that mean that the state does not have the right to stop any violator NGO from operating in Egypt? No, of course, the state has this authority. We can refer to other laws like the laws regulating the corporate world, for example. So a number of founders should submit an application with all the required documents, and if the state or the national authority sees that there is something not in line with the law, then they should resort to the summary judiciary. But the point I'm stressing is that registration and establishment should be upon notification. Also, the purposes of associations, in my own point of view, we should avoid the fact that the law or its executive by regulation should give an exhaustive list of NGOs, because new fields emerge on a daily basis. Maybe new needs emerge. So most of the things should be permitted in the law, especially in the civil work, and we could have certain activities that can be considered prohibited or forbidden. Of course, political activities, syndicate works, because this should be given to syndicates and professional associations. Um, just like the old law, of course, forming any military or paramilitary wings should be prohibited. But people should convene to organize their own needs, their own daily lives, or convene to serve the country. So all development activities or human rights protection related activities should be permitted. And this takes us back that we should allow all the activities, and here I am quoting some of the text. Of course, political activity is prohibited, syndicates work is prohibited, military activities is prohibited, promotion for election campaigns is prohibited, because of course it's not in the scope of the NGO to support a certain candidate. Of course, making profits, racism, hatred and incitement are all prohibited activities. But we should allow all the NGOs to practice non-profit activities, provided that it's not part of this black list activities. So those people who deal with the NGO sector on a daily basis know that these disturbing details are really annoying. So listing an exhaustive list of the activities is very disturbing. And if you limit your scope to this activity, then you cannot move to practice other activities. So I will set an example. In Asyut, we have an activity to promote or support healthcare, and we wanted to establish a unit for supporting children with disabilities, and we were told that no, this is not another this is another scope. So we have separate fields. We have promoting healthcare and supporting children with disabilities. So how come I'm allowed to do certain things but not other things that are directly related? It's not about following legal text, it's about the rationale, and we should liberate the text. We should give much freedom, since there is sound control and supervision over that.